Good afternoon, everyone. My name is Vera Kirojan, and I will be your moderator for today's webinar titled Belgian Private Security Cartel, Are You Entitled to Compensation? We are here to discuss a significant development in the Belgian security sector. On the 2nd of July 2024, the Belgian Competition Authority, or the BCA, issued a final decision regarding a long-running cartel involving the three largest players in the market, Securitas, G4S, and Seris. Today, we want to explain what happened, how it affected you, and most importantly, how you can recover the damages you suffered. I am joined by three experts who will walk us through the legal, financial, and economic aspects of this case. We have here Jasper de Val, a lawyer at deprevernet, who will explain the legal background. I'm also joined by Juraj Siska, partner at LitFin, who will explain LitFin's working method. And we also have Mate Fodor, partner at Theseus Economics, who will briefly touch upon how we calculate the damages and the overcharges. Jasper, the floor is yours.
Thank you, Vera, and thank you for the invitation to speak at this webinar on what is indeed a very interesting case and what can be a big opportunity for cartel victims to claim damages. I'm Jasper. I'm a partner at deprevernet, assisting LitFin in this matter, and I will walk you a bit through the legal background of the case. So as you said, the decision dates back from 2024, but in fact the instruction was opened a few years earlier in 2020 with a leniency application, and history says that the BCA was ready to do their down rates just before the moment that the entire country went into lockdown due to COVID. It's already back then. But that didn't stop the BCA from conducting its investigation further, and eventually all parties applied for leniency, and they also made a settlement with the authority, which makes in fact that the decision is a decision of the Auditorat, which is the investigative body, and not the Competition College, which is the decisional body. So it's a settlement decision. All parties acknowledged the infringements and also agreed to enter into that settlement decision. From a legal point of view and a procedural point of view, it has important implications, as the decision is no longer open to appeal. The decision is final, can no longer be appealed before the market court, which would have been normally the case with the BCA decision. So this decision is really final now. It imposed serious and substantial fines on the cartel participants. As to Securitas, it's got a full immunity as a first leniency applicant, and the other two got substantial fines. When we look at the infringements which were found by the authority, those are in fact, if we look at it, those are the really infringements of a hardcore, old-fashioned classic cartel, and again, it are infringements which are all acknowledged by the cartel members. So what are we talking about? We're talking about horizontal price fixing. We're talking about really agreements between cartel members on the prices that will be applied, and which prices. In particular, they agreed on minimum prices. So they had a professional association. Within that framework, they agreed on minimum prices to be applied. They shared information notes on that. They made an indexation model, and it goes even further, because when they saw in the market that there were deviations from that agreed horizontal price, they criticized also each other on not having applied their agreed prices. They provided thus their numbers to each other, and they discussed really cost-related and thus sensitive information amongst each other. That's the first part, is really a price-fixing cartel. Secondly, the BCA also found that this is really, we're really talking about market and customer allocation and bid rigging. What is that about? It's in fact about an agreement on the attention or the coordination to bid on certain projects. So when there was a private tender launched or a public tender launched, the cartel members discussed amongst each other the intentions to bid on a certain project, intentions to participate, and they also discussed on all the surrounding circumstances such as prices, and again they exchanged information on those bids. And then lastly, but that is a bit less interesting for this case, or especially in terms of private damages, is okay, there's also non-poach, which was found by the BCA, which is now also a priority of a lot of competition authorities. It is about the fact that the employees could not go to the other companies. So it was, in fact, it's also a competition law infringement. What brings us, in fact, to the general aim of the cartel, and that is also which is really found by the authority and which was acknowledged by the cartel members, and that's the general aim of the cartel. And that's also important if we're talking about who could have been the victim of this cartel. The general aim is bring stability, bring rest in the market, keep each other's contracts, keep the contracts from each other and clients, and do not attack each other on these contracts in an aggressive way. So it's really rest, stability in the market, keep it as it is. And obviously those are serious infringements of competition law. When we're looking at the scope, as you already said, indeed, it's a long-lasting cartel. We're talking about 2008 till 2020, 13 years in a row that there's a cartel, which was found by the authority. That's the period which is acknowledged and found by the authority. The scope of the services, we put them on the slide. It's broad. Aviation as a sector is especially mentioned. If we look, for instance, at money transfer, that seems to be excluded. If we still look at some other important findings of the authority, which are also of a relevance here when we're talking about private damages, is that we're not talking about some small players in the market who made an agreement. We're really talking about the three biggest players in the market who represented at the time over 80% of market share of the entire market. So it's a market-wide infringement. And what is also important in that very concentrated market is that the authority found that a certain number of contracts can only be done by a limited number of players, in particular those three, because for those contracts, for those services, a special number of, for instance, employees or other resources is required, which makes that in the end it would always go to one of those three. So we also see that the members really exchange a list of most wanted contract, but again, that does not mean that if you're not on the most wanted list, that you're not a victim of the cartel, as this is really a market-wide infringement. When we're talking now, that's a bit the legal background of the case, but all of this is obviously public enforcement. Public enforcement being an authority going after cartelists and really fining them for their behavior, which is an infringement of competition law. And from a public enforcement point of view, the end point is imposing fines. There it stops. But in fact, as to private enforcement, that's mostly the moment where everything begins. And in fact, then we can see that, okay, we have fines which are imposed, which go to the Belgian state, but that obviously doesn't help the cartel victims themselves, who paid during a long period too much for the service. Those victims, they can claim damages. Those victims can claim damages, and in fact, this is a tort claim introduced before a civil court. So you claim damages. You could say, okay, is this a normal tort claim? It is, with some particularities, and in particular with some specific rules. And there are even EU-wide rules which are now imposed in all EU member states. There has been an antitrust damages directive which is transposed in all countries. And in fact, the general aim of the EU antitrust damages directive is to help antitrust violation victims to claim their damages. There are tools such as, for instance, the fact that the value of a decision of the competition authority already establishes a fault. There's also a presumption that cartel infringements, such as the one at hand here, they cause harm. So we have a legal presumption that such infringements, they cause harm, which makes that the burden of proof to say that there's no harm, that there's no damages, rests on the cartelist. And further, there are also specific rules, obviously, on production of documents and specific rules on the statute of limitations, in particular that the statute of limitation period cannot start to run before the final decision is issued. So that was here in 2024. So I think that was a bit what I wanted to say on the legal background, Vera.
Thank you very much. Thank you very much, Jasper. I will now give the floor to Juraj, who will talk to us about LitFin's working method and a little presentation about LitFin as well.
Thank you very much, Vera. And thank you very much, everyone joining us today. And thank you very much, Jasper, walking us through these important legal aspects. As Jasper said, victims can claim damages, right? But these claims for damages are usually very complex and can become expensive. And this is actually where LitFin helps. LitFin is a litigation funder. So what the litigation funder does, we fund the litigation. We pay for the costs. We cover all the related costs to the litigation in exchange of the commission at the end. So we are not remunerated if we are not successful. On the other hand, what the LitFin does is that we manage these cases. So we take care of the relationship with the clients, the onboarding, all management of the organization of these cases. As I said, that can be very, very complex. LitFin as the group, we have almost 100 people now around Europe in different offices, including our Belgium office in Brussels. In total, we have more than 6 billion euro claims now in all the courts. When it comes to our focus on the cases, on one hand, we have cases related to financial frauds and healthcare and banking and commercial law. But on the other hand, our priority and our focus is on competition law, and especially on the group claims. There are cases related to the abuse of dominance, as the cases you can see on the slide, like where we act against the big tech companies. But also on the other hand, we have several cartel cases, such as the pesticide cartel or the drug cartel or the cartel of private securities that we talk about today. LitFin's role, if I put it really in a nutshell, it's to transfer a claim, a legal claim, into a valuable financial asset for companies. When it comes now to the working method of LitFin, and we work on a so-called no win, no fee system, which means, as I mentioned, we are remunerated only if we win. So if the claim or the case is not successful, we are not remunerated at all, and we still bear the whole financial risk. So actually, no win, no fee principle, it's about shifting this financial risk from the client or the victim in the cartel cases to us. On the working method of LitFin, in this particular case, we apply so-called assignment of claims, so in French, la cession de créances, meaning that the companies or affected companies and the victims, they assign their legal claims to LitFin, and then the LitFin goes to the court while taking care of external lawyers and economists and all the costs. Of course, to this model, we have also different alternatives that are more suitable, or in some cases even the companies they have to choose. But we will talk about it maybe a bit later. Now, in this case, in the private security cartel case in Belgium, we already have a group of companies, and there are still companies joining, and we are in touch on a daily basis with affected companies in order to create as big group as possible, but also with the solid data set and economic calculations that Mate will talk about. So in our group, it's not only about the private companies, but also the semi-public companies, but also fully public companies. So basically anyone who can be the victim of the cartel and who paid at overcharge. Now, let's talk about a little bit of what would be the next step if a company wants to join. So first, I invite everyone to contact us. So we can organize a preparatory meeting, whether it's online or in person. And after we explain the case more in detail and we are in touch, we sign a so-called NDA, so the non-disclosure agreement, in order to protect the confidential data from the company side and to protect the confidential documents and information from the LitFin side. When all this is done, we prepare a so-called preliminary damage assessment in order to see whether the company is affected and whether it's worth or it makes sense for the company and for LitFin to join them to our group. All this is, of course, confidential under the NDA and for free. As I said at the beginning, LitFin covers all related costs since the very beginning till the very end of the litigation. After we analyze the first preliminary set of data, we negotiate the contract. So either it's a assignment agreement or other type of a contract, the LFA or the mandate, and then we join the company or the victim of the cartel to our group, so we can initiate the enforcement of their rights. So this was maybe all from my side. Now I will leave the floor to Mate to walk us through the economic aspects that are very important in order to enforce the rights of the victims.
Thank you very much, Juraj, and for presenting your very unique and interesting way of working. My name is Mate Fodor. I am a partner at Theseus Economics, and I would like to briefly walk you through a key aspect of what's going to happen as part of the next steps. One of the things that Juraj just said is a preliminary damage estimation. So it's one of the immediate next steps that we are coordinating together with LitFin and with deprevernet as well. This is a step that is important for you as well as for LitFin. Have an idea about your involvement, your engagement, and what that brought in terms of damages and how that can be substantiated and then communicated properly to the courts. That's what we do as a company. Theseus Economics is what we call an antitrust economic consultancy. What we specialize in are various affairs of competition law, but we don't handle the legal aspects of these proceedings, such as mergers and acquisitions, complaints in antitrust cases, and then also the recovery and quantification of damages. However, we also communicate with the courts just like the legal experts do, because we make the necessary economic claims and arguments in a credible way that is always substantiated by data and by very scientifically rigorous, what we call econometric, but you might think of it as a statistical analysis. That's what we specialize in, and these cases always need an economic expert that does this. In this case, we will be helping you with that, and we are one of the players on the market of other companies that do almost exactly the same thing. In our case, we are currently engaged in numerous European and national damage quantification cases. A few of them are here on the slide. We are active in various regions in Europe, including German-speaking countries, French-speaking countries, and we have a dedicated team that you can see on this group photo of specialized economists and econometricians who work every day in substantiating these claims and quantifying them, making sure that the courts and the other side of the proceedings understands exactly where our arguments are coming from and how that can be shown in hopefully an irrefutable and causal way. What we try to understand is what is the actual harm that nothing else but the cartel's behavior has caused you. And that is what you are going to be entitled to be compensated for. And the way that you should think about this is going back in time, which if you are a movie fan, you probably noticed the DeLorean over there from Back to the Future, because that's exactly what our job is to bring everything back to a timeline in which everything else that you experienced would have been the same as it was, with the only difference is that there would have never been a cartel on the market for private security services. That means that cash would have stayed in your pocket. And with that cash, you would have done things. You would have invested them, you would have grown. Our job is to make sure that this is well understood by the courts, it's well quantified, that we exactly identify how much more you paid than you should have, and then also what you would have done with that money. This is a very important aspect of damage recovery, and this is how you have to think about it. But of course, that alternative timeline is not something that anyone can see, which is why we need to construct it with econometric methods. We need to model a world in which all the variables that influence security expenditure and your general needs for security services would have otherwise remained the same, but you would have paid fair prices for those very same services. And to substantiate that, an expert opinion will be issued and will be submitted to the court that is handling this case. This is also very important to be prepared if there is a negotiation that happens before the court proceedings. This expert opinion has certain rules that it must follow. It needs to be a credible and irrefutable piece of economic quantitative evidence backed up with the right set of arguments that is going to be extremely difficult to refute and that is going to form the basis of what you are claiming in the court and what the legal experts like Jesper is going to fight for when it comes to making sure that your rights are validated in court. There are certain advantages of claiming these recoveries as a group. Claiming as a group obviously puts the claimants in a much stronger bargaining position to start with, but it also makes the entire claim much more credible, especially when across claimants we are able to find and substantiate similar degrees and similar natures of harm. That always makes it a much more valid claim and something to take much more seriously than when it comes to individual claimants. And of course, by joining as a group, the efficiency of our work and the legal work is facilitated, not to mention the financial side of that, which Uri has also already spoken about. Also, there is a certain element of deterrence when stepping up as part of a group, certain element that shows that every single member of the group has a desire to make sure that whatever happened in the past never happens again. And it doesn't just send a message to private security companies, but to all other suppliers that you might be working with at the moment, working in similarly concentrated markets. You show that if anything like this happens again, you are ready to step up and to claim compensation, which is an extremely costly endeavor for the cartelists to have to face. And that's a proper deterrent, because even more than the public enforcement, which Jesper de Vau has talked about, private enforcement is actually much more scary to cartelists, usually in most cases. What we are going to need from you when we do the preliminary damage estimation is a little bit different than what we will need for the final expert opinion. The most important thing that is going to be necessary for us to see is to have an overview of the different agreements you've had, not just potentially with the cartel members, but also with other Belgian private security companies. We are very much interested in the expenditures that you have devoted to private security services. And we are also very keen to get to know the extent of the need for private security that you have, the size of your premises, the value that is being guarded, the people who are being protected at your premises, the events that you organize that need special intervention from private security agents. All of these dimensions, and the more we know, the better preliminary diagnostic we can give. And we are going to send what we call an RFI. And there's been a lot of abbreviations already thrown around today. But that happens to stand for a request for information, in which we are going to detail what we need. And we're also going to give you a possibility to provide us with that data in the simplest possible way, in a way that's easiest for you to recover. And we're very happy to help you recover anything that we might need for this exercise. And then even later, once an agreement is signed between you and LitFin, even more so, the more granular data we will be able to communicate to you and to help you recover very actively. So you're not alone in this. And even if you think you don't have the proper data at hand at the moment, you don't need to worry. For the preliminary damage estimation, we do not need too much. And then once we do need some more pieces of information, our experts will be there to guide you through the process. With that, this is our contact information. We are very happy to answer any questions that you might have regarding the economic evidence that will be necessary. And I think with that, we are going to come a full circle and give the floor back to our moderator, Vera, for the next steps.
Thank you very much, Mate. I think this ends the presentation part of our webinar. I would like to thank you very much for your insights. And we remain available if you have any questions. You can contact Uri and our team at LitFin. We will now move to the Q&A session. And feel free to ask any questions in the chat, of course. I actually have a few questions that usually come up in our initial meetings with potentially affected companies. So I actually have a question for you, Jasper. You mentioned earlier on that these three firms held over 80% of the market. Does that mean that a company can still claim damages even if they use a different, smaller security firm? Is it possible that their prices were actually pushed up by this cartel?
Okay, yeah, that's a very good question, and it comes indeed up with people who think, okay, we did not work with those three players, those cartelists. So am I also affected by the cartel? The answer is yes, it can be, because that is what we call in technical terms, and potentially Mate, you will join in on that point, because there's also an economic aspect. That's what we call the umbrella effect. In fact, what is the umbrella effect is the fact that as we have a cartel which affected a large majority of the market, it's possible that general price levels within the market went up. And it's especially true in markets where, for instance, there's a lot of private and public procurement, where there is certain insights in prices. For instance, if a public procurement process is done, and when a public entity chooses a certain service provider, it usually also publishes in a certain way the prices or the offers that it received from other parties, where non-cartel members might think, okay, well, we see that this is a general price level, and those three they made such offers. So maybe that's a good idea to raise prices in my next offer. So. Or even within private negotiations where you are negotiating with a certain client, and where the client says, well, I already received an offer from, for instance, Securitas, and they offer that, can be an idea for a non-cartelist member to raise prices. So all these factors, they may incentivize non-cartel members also to go towards the general price level which was applied within the market. And just from a legal point of view, under Belgian tort law, it's perfectly possible to claim such damages. And also, this has also been confirmed by the European Court of Justice already in a judgment that umbrella effects are real, and umbrella effects, they can be, the damages which are due to the umbrella effects can be claimed from the cartel participants. I don't know if you want something to add something, Mate, on umbrella effects.
You explained everything perfectly. In no better way could an economist explain it. The one thing I would like to ask or add to that is that the umbrella effect, especially in cartels, where there is such a highly concentrated market, with such a massive part of the market that was engaged, it is very difficult not to imagine that an umbrella effect would not show up in the data. Rational agents operating on such a market, as Jasper just said, once there are any price signals that become public, it would be foolish not to align prices to those price signals, especially when it's the largest firms doing it. So those companies that did an alignment to the price signals, but were otherwise not part of the conspiracy themselves, they will not be held liable for what happened because they innocently followed the price signals that were available on the market. However, even to that price increase, which otherwise, but for the cartel would not have happened, they are still jointly and severally liable. I realize I just repeated a lot of things that Jasper said in different words, but that's how you have to think about it. So in sum, yes, please do contact LitFin if you had a contractual agreement with a company other than G4S, Securitas, or Seris, because there is a high probability that we, as a collective of experts here, might be able to help you nonetheless.
Thank you very much. Thank you very much. It's much clearer now. I have a question for you, Juraj. You mentioned a no-fee model. To be absolutely clear for our audience, if the case is lost in court, is it true that the claimant company owes nothing for the cost for the lawyers or the economic experts?
Well, the question is very, very common, and the answer is very, very fast. The answer is yes. We cover everything, and no, the company has nothing to pay. Really, here the business model of LitFin and other litigation funders is to cover all the related costs. So also our internal, external costs, whether it's related to administrative costs, because of the economists, lawyers, data cleaning, etc., etc. So it's really the idea is the company doesn't pay anything when joining the case. But as I said, in exchange, we take the commission, but only if we win. So it is based on our risk assessment. We are very picky, like when it comes to the cases. So we analyze and we choose only the cases where we really believe that they are economically, meritoriously, from the legal point of view, good, and we can invest our money into that. Which also gives the opportunity to the companies to join these meritorious cases that where we believe we invest our money, and they have nothing to pay if the case is successful, if the case is not successful. And this from the very beginning, starting with the preliminary assessment until the very end, whether the case is closed with the judgment or the out-of-court settlement.
Okay, thank you very much. I have another question for Mate now. And this is also a question we get quite often, actually. What if a company doesn't have records going back to, let's say, the very beginning of 2008? Can your model still calculate their damages even if there's gaps in the data?
Absolutely, gaps, and also in some cases, no real counterfactual, no real competitive period to compare data to. And we very often get that also for companies that may have gone out of business after the end of the cartel, who are still pending some legal aspects of it, are still eligible for damages because they did suffer those damages. When we have such data gaps, there is a lot that we can do to complement from the econometric analyses that we do on comparable businesses, which again highlights how important it is and how optimal it is to approach this entire claim as a group. Every type of data gap is fillable by a big group that contains similar businesses working in the same sector or of similar size. And because of that, it is something that we can deal with as a collective, and that would be almost impossible to deal with on an individual basis. Approaching this problem when you have data gaps like that, and possibly even a complete lack of data, would be completely impossible if you were to sue these security companies on your own. But as a collective, there is still a chance that this might be remedied. So we very much encourage you to step forward. Let's discuss what data you have and the most that we can squeeze out of that data, because that's what we do. And in every case that we work on, we always discover that there is some sort of a lack in data coverage, but that's our bread and butter. We make sure that that problem is solved.
Okay. Thank you very much, Mate. Now I have another question for Jasper, which is maybe more, again, on the legal aspect. We have also heard sometimes that some procurement teams, for example, they feel they were protected because they participated in a competitive tender. But the BCA, as you mentioned, found evidence of coordination in relation to various tenders. So how can a customer be a victim even if they thought they were getting real competitive offers?
Yeah, that's an interesting question, but maybe just as a preliminary point before responding to that, we need to look at the decision. If we look at the decision, we see the decision does not name any client names or projects. But again, this needs to be clear. This does not mean that the market did not suffer harm. The fact that there are no specific clients and no specific projects which are mentioned is all due to the fact that this is a settlement decision in which the cartelists had their say on what will be in the decision, what will be blacklisted in the decision, what will not be mentioned in there. And the fact that there are no names or no projects is only due to that. But let's take a step back here, and if we take the step back and just trying not to repeat myself of the presentation, but we have a cartel of 12 years, really covering the entire market, with a general aim to make the market stable and to not attack each other. So, but obviously all of this was hidden, and then it's obviously clear that when a client in good faith makes a public tender or makes a private tender and receives different offers, obviously the client in good faith thought, okay, this is good. The market is competitive. I receive competitive offers. I receive offers from different competitors, and let's take the best one. But in fact, all of this was one big scam, and in fact, it was all falsified. Which makes that also the offers were falsified, and which also makes that even though a project was set up for competition, as the competition was falsified, also the tender is falsified, and also the fact that eventually when you choose an operator which seems to be the economically best solution, even that solution was in fact surcharging you. So it does not mean that when you have put something in competition during a cartel period, that it would not lead to damages in terms of overprice. So hope this responds
Yeah.
question.
Maybe if I can add on that, this is also one of the key points of a cartel, is that it's secret, right? So it's secret, so they can secretly create this conspiracy. And also as a former cartel investigator, I can say that this is where this first part of Jasper's presentation of the public enforcement actually is very important, because authorities, they will discover it, they will find out about the cartel, they will do the down rates, they will prove it, which is the case in this particular case of private securities. This was already proven. It's here. It's not secret anymore. So the companies now they know. Now they are aware of this damage. And as you said, they obviously were not when it was happening, because again, one of the key elements of a cartel is that it's to keep it secret, right?
Yeah. Thank you very much. It's true. It's a question we get often, so I think it's good to clarify that particular point. I also have another question for you, Juraj, which I think also comes close to what you said, Mate, before. Why is joining a collective action better for a company actually than just suing on its own? Is it just about saving money, or does also bundling claims actually help make the legal and economic aspect of this case stronger?
Thank you for the question. It's a bit of everything. I think Mate went through why, from the economic point of view, it's very beneficial to join the group, but also from the strategic, procedural, legal point of view, if I can put it like this, it's very important, because there is this strength in the group. So also the bargaining power is larger when it comes to the settlement discussions, but also there is this effect of the economy of scale, that sure, we pay for everything and we cover all the costs, but actually it becomes more financially interesting for a given company to join. And which I think is important to mention, that our group, whether in this case or other many cases we do, are composed by not only the companies with small claims, but also the medium or like very large claims, that maybe from the first side you would think that they can do it by themselves, but actually even the big companies, they understand that this €1 invested into litigation maybe can be spent somewhere else, right? So we take off this financial aspect, and also, as I said during my part of the presentation, the financial risk is shifted on us. And also for the small companies, or like the companies with smaller claims, this is where actually it makes a lot of sense to join, because their rights it's very difficult to enforce them. Just make the calculation. So to join the group is also from the economic point of view, also from the practical point of view, to join it, increase the bargaining power, and also give the companies the possibility to have the founder behind, to have the good experienced lawyers, economists, to be there, to be part of the group, and to increase the chance and for sure the speed of the recovery.
Okay, thank you very much. I have another question now for Mate. For those of us who aren't economists, what would you say is the single most important piece of data a company should start looking out for today to help calculate their specific damage?
Expenditure. What we would like to know with the most possible detail is how much you have spent and on what exactly. But even if we don't know on what exactly, the beneficiary of the money that has left your company for private security expenditures and assigning a monetary amount to that over the years from 2008, if possible, all the way to 2025, such that we have something to compare to, would be the first and most essential piece of evidence. Obviously, in the request for information, there will be other things that we will be asking for, but expenditure is the most important thing. And then on top of expenditure, another thing that would be very helpful is an identifier of the contracts that you have had with private security companies. We need to know when these were concluded, when these were tendered, and how long they lasted. Is one big thing that comes up very often in the calculations that we do. is that a lot of security contracts started during the cartel and kept operating in a completely unchanged way well into 2022, 23, 24, meaning that the market and competitive conditions in which they were conceived were suffering from cartel overcharge, which has then been transplanted into the period after the cartel, unless it was, of course, retendered or otherwise renegotiated. But expenditure is the most important thing. If you have nothing else, it's expenditure that we can get started on. Okay. And then, on top of that, if you already have some contract identifiers, tendering processes, and the outcomes of those tendering processes even better, then we can give you a much more precise estimate. And then we will need a lot of other things, but as we said, we will help with the recovery of those from your records, with the extraction from your records, so there isn't too much to be afraid of. And the expenditure data is usually not too difficult to recover for claimants.
Okay, thank you very much, Mate. So we know now that expenditure is really the key data to have. I have now another question for Jasper. Maybe this is something we didn't go into more detail in, but I wanted to talk about the joint and several liability principle here. And the BCA, in its decision, found that these companies are jointly and severally liable. Does this mean that a victim company who only worked with one provider can actually claim their full damages from any of the other companies or even their international parent groups?
Yeah, that's also interesting, and I think we need to make a clear distinction between public enforcement again and private enforcement. If we look at the public enforcement element, there we see indeed, and that's quite classical, that in the BCA decision, both the Belgian companies and their international, in this case international mother companies, were held jointly and severally liable for the infringement and also to pay the fine. But that's obviously per cartel member. That their mother company is also liable for the infringement and the fine. From a private enforcement principle, from a private enforcement aspect, the situation for the victim is even better because there are certain exceptions for a first leniency applicant, but let me put it that way as a general principle. As a general principle is that all the cartel members are jointly and severally liable towards the victims. So even though you did not conclude a contract with one of the cartelists, your damage can be claimed from any of them, from any of the cartel members, because they are towards the victims. They are all jointly and severally liable towards the victims. So you can go after one or all of them. And in fact, the division of who needs to pay what to which victim, that's a division which needs to be made among the cartelists, and they can have claims amongst each other. But as a victim, that is not your problem, to put it that way.
Okay. Okay. Thank you very much. I don't know if on this you wanted to add something, maybe Uri, from experience or yeah.
From our experience, this is actually one of the key points that maybe sometimes underestimated. It's that really people ask us that, can I really claim if I didn't use the services of that company or that cartelist, or even what we mentioned before, someone who was not really in the cartel. So here the idea is to facilitate and make it easier for the victims to claim it, right? Because they have less knowledge, they have maybe less chance to claim these damages, and the cartelists are sometimes in a better position. So the law is here actually to help them in order to achieve this, what we call from the EU law perspective, the full compensation they have right to.
Okay, thank you very much. I have another question now, which is also sometimes a more commercial or practical concern for many companies, which could be of interest in the audience, is about the ongoing business relationship with these providers. And if a company is still a client of Securitas, G4S or Seris, or has a contract renewal coming up, let's say, how does joining such action, for example, protect them from potential commercial retaliation? I leave the floor to Jasper, but also to Uri.
Yes, I think if I just can first look at it from a legal perspective, I think if there would be any retaliation measures from the cartel members towards their clients because they are just exercising their rights, that would be a very bad idea. I think that we should also not turn the way around. I mean, it's not the clients, it's not those the cartel victims who infringe the law here. They're just exercising their rights, which are protected under Belgian and European law, and they're just exercising their right because another party infringed the law for a long period. So they were frauded, and they were just exercising their rights. And I think that's not only would be a bad idea, it would also be a very risky business, because if that would be really the case, I think that the next day a new complaint would be filed at the desk of the BCA, and the BCA would be very interested to look into that, as obviously in competition law we have public enforcement, we have private enforcement, but the authorities, and if we look at all authorities across Europe, they all say like, okay, we need to stimulate also that the private enforcement aspect. So we really want to also help victims with that. So if anyone would be hindered in claiming damages, that would be really again against all principles of competition law. So,
and this even more in the context of a settlement decision, where actually the cartel is entering into discussion with the authority in order to achieve the settlement. It wouldn't make much sense. And maybe this is one of the points I forgot to mention about why to claim in a group, right? Like when you are part of the group, you are a bit more protected, because if there is any retaliation measures, they if they really wanted to do it, I mean they should do it against many companies at the same time. And from our experience, it just doesn't happen, because as Jasper said, it doesn't really make much sense.
Economically as well, I just took it upon myself to add something, and I wasn't prompted. But an idea came to me while I was listening to your ideas, is that from a game theoretical and economic perspective, it is also very irrational to retaliate against those who are claiming something from the past. The past is the past, and it needs to be closed in a way that everything is going back to an equilibrium. But these companies want to keep doing business on the Belgian market. They want to occupy 85% of the market, or even grow their joint market shares. And doing so after a phase of retaliation, which is a relatively petty and pity and a small kind of vindication that they might have, would hurt those business prospects much more than not doing it. And also, don't want to repeat what we've already said in the presentations, but there's a hidden cost of not doing anything. Now, that's an issue, because the hidden cost of passivity is knowing that moving forward, these companies will be more lenient towards those that have harmed them. And that creates a bad precedent. That creates a precedent where service quality may be diminished, pricing may be adjusted in a way that reflects those, and the difference between those who are actively pursuing their rights and those who remained passive. So from an economic and game theoretical perspective, it's more dangerous to stay passive. And we would certainly not encourage you to do that.
Okay. Thank you very much. I have another question that we get sometimes is, how much time do I have to act or to introduce a complaint? Is there a specific time period?
Yeah, so legally speaking, the statute of limitation period is 5 years in Belgium. So and it can only start to run as from the decision. So that was in July 24. So victims still have, in theory, up to 29 to introduce proceedings, because once proceedings are introduced, statute of limitation period is in any event suspended. But that does not mean that victims need to wait until that very date. We already discussed the fact that data will get older. It will in 2029 it will not be easier to get data from 2008 than it is now. And obviously now there's a train moving. I mean, we have LitFin as a litigation funder who is constituting a group. And obviously we are now, LitFin is now contacting the markets on that. And as from the moment LitFin has a sufficient critical mass, to say it like that, LitFin will instruct us to start the proceedings. And once that train is moving, and once that litigation, and once that proceeding is on track, it's obviously it's no longer possible to join because the proceedings are introduced. So there is a momentum now. We are really preparing this case now, and potentially once the train is on track, it's gone, that opportunity. So it's more an economic and commercial element now to join it now than a purely legal element.
No, thank you. It's from strategic point of view, and for us is to is not really to wait until the end of limitation periods. I mean, like as you said, we are now constituting the group, so now is the moment to join, because we don't want to make companies in the group already, or they are joining now, to wait the years, because as we say usually, is that our interest as a litigation funder, it's fully aligned with the interest of the companies actually claiming the damages, right? You want to have the damages and the compensation as fast as possible and as much as you can, right? Because if not, we are not remunerated again. So it's really in the interest of everyone, the whole group, to create a solid group with a solid economic reports and calculation, with a solid legal basis, and not to wait the end of limitation periods, but to do it sufficiently soon, so everyone is actually happy.
Okay, thank you very much. I think this concludes our Q&A. I would like to thank again our speakers, Jasper, Juraj, and Mate, for their time and expertise today. And so I think the takeaway is quite clear. For 12 years, this cartel distorted the market. And so if you purchase security services during that time, you likely paid too much. And so our goal is to help you recover the losses at no financial risk to your company. As for the next steps, again, please contact Juraj or myself. And I would like to thank you for joining us today.
Thank you very much.
Thank you.